Juvenile life sentences without parole are not cruel and unusual punishment by Reagan, Sarah, Brandon, Joy, Jordan, Megan, and Allie. Introductions. Juvenile life sentence without parole is the determination that a juvenile's crimes were so heinous that they will never be able to change their life and learn from their actions. This also means that they will not be rehabilitated back into society. Currently, over 2,500 kids have been sentenced to life without parole starting at the age of 13. The United States is the only country that condemns a minor to spend the rest of their life in prison for their crimes. To continue on with the introduction, between 2005 and 2016, the U.S. Supreme Court issued several decisions banning extreme adult sentences for the youth. In Roper v. Simmons, the court banned the juvenile death penalty. In Graham v. Florida, the court banned life without parole sentences for youth convicted of non-homicide crimes. And then in Miller v. Alabama, the court banned mandatory sentences of life without parole for youth convicted of homicide crimes. Youth may still be sentenced to discretionary life without parole in homicide cases, but only after the sentence court has determined after a full hearing that the youth is permanently incorrigible and incapable of rehabilitation. To give more visual of the timeline of the cases, here's the history of juvenile life without parole sentencing. First, you have Roper v. Simmons. In 2005, the Supreme Court banned the capital punishment sentence for juveniles. Then in 2010, you have Graham v. Florida. The Supreme Court banned for the use of life without parole for juveniles who committed crimes other than homicide. Then in 2012, we have Miller v. Alabama and Jackson v. Hobbs. This is where the Supreme Court ruled that mandatory life without parole for juveniles was unconstitutional. Then the most current case is in 2016 versus Montgomery versus Louisiana. This is where the Supreme Court made the Miller ruling retroactive. One of the key cases that we want to focus on is Montgomery versus Louisiana. In this case, in 2016, the United States Supreme Court case in which the court held that its previous ruling in Miller versus Alabama that a mandatory life sentence without parole should not apply to persons convicted of murder committed as juveniles, should not be applied retroactively. The court's analysis in that case was based on the precedent that established that the Constitution treats children as different from adults for the purpose of sentencing. Therefore, the rule of the court announced in Miller made life without parole an unconstitutional punishment for a class of defendants based on their status as juveniles, and such a rule is substantive rather than procedural. Now that you know the background of the actual Louisiana case, we want to focus on the actual dissent given by Justice Anton Scalia. His opinion is what we're more trying to prove with the concept that juvenile life sentence without parole isn't cruel and unusual. In his dissent, he states that the court did not have jurisdiction to decide this case. Because Supreme Court precedent treated cases on collateral review from the state court decision differently from those on direct review from federal courts, the principle of finality of decisions dictates that whether new constitutional rule will be applied to a final state court conviction is entirely a matter of state choice. Meaning, a state court need only apply the constitutional rule that existed at the time of the conviction, and the court does not have the jurisdiction to review that decision. He then argues that the precedent the majority relied on for its conclusion was not binding and did not directly apply to that case at hand. To continue on with this topic, we want to focus on what he states at the end of his dissent, which is the question of whether a constitutional right is retroactive asks whether there is an appropriate remedy, not whether the right was violated in the first place. Because the Supreme Court cannot force state courts to apply constitutional rules that did not exist at the time of the conviction, there is no constitutional mechanism to provide a remedy that would make the constitutional right in question apply retroactively. Basically, Justice Scalia is arguing that the precedent that the majority relied on for its conclusion was not binding and did not directly apply to the case at hand, making this null and void. Now that we've gone over the cases that preside over this topic, we're going to focus on the current life without parole for juveniles. Currently, to issue a juvenile a sentence of life without parole, the case is weighed on its own merits and cannot be issued based on mandatory minimum sentencing requirements. According to the Montgomery ruling, this sentence should be reserved for the rarest of juvenile offenders, those whose crimes reflect permanent incorrigibility. Currently, 29 states allow this sentence for juveniles. 2,100 of the 2,500 currently incarcerated under this sentencing became eligible for review after the Montgomery ruling by the Supreme Court, meaning that 400 of those juveniles currently serving life without parole sentences were given the sentence based on their case's own merits. This seems in alignment with the sentiment expressed in the Montgomery ruling that these circumstances will be rare, but this does not mean that it's not warranted. We need to preserve a ruling like this, so just in case of these rare cases where these types of juveniles should not be able to be released back into the public because they can cause more harm. Now we're going to get into why it is not cruel and unusual. In U.S. Supreme Court Chief Justice John Roberts' dissent letter in our text, Taking Sides, Justice Roberts argues that a life without parole sentence for juvenile does not violate the Eighth Amendment. Justice Roberts argues it is not cruel because a mature society may determine that this requires removing those guilty of the most heinous murders from its midst, both as protection for its other members and as a concrete expression of its standards of decency. It is not unusual because juveniles being tried as adults is a common practice. Murder is unlike any other crimes and should be treated as such, regardless of the offender's age. Now, banning death penalty sentences for juveniles already creates a special analysis of the Eighth Amendment, but was only passed because the option of a life without parole sentence could still be used today. Now we're going to be looking at another case providing over this topic. This case is Bunn versus State of Georgia. The case, on July 20th, 2011, 17-year-old Bunn was pulled over by several officers because he had a warrant out for his arrest in connection with a robbery and aggravated assault. Bunn pulled over his car, but when Officer Daly approached Bunn, stepped out of the car and fatally shot Officer Daly. Bunn also fired at nearby officers as he fled on foot, but was sentenced to life without parole. The appeal, in 2015, a year before the Montgomery ruling, Bunn appealed his case, arguing that a LWOP sentence consisted cruel and unusual punishment under federal and Georgia constitutions. The Georgia State Supreme Court ruled in favor 5-2 that evidence was sufficient to support a homicide conviction. A discretionary sentence of LWOP on a juvenile for homicide was not cruel and unusual punishment, exerting their right to discretion in juvenile crimes where the crime is particularly heinous. Now, if you look at this, we're not trying to apply the sentence for any juvenile sentencing. We want to focus on the more heinous crime. That shows that they have the mindset that they understand what they're doing and that they have the capability of taking another human's life. So that means they can be tried as an adult. Since we've given you our perspective, we want to show you the other side of the argument. Through psychological perspectives, there are ultimately numerous reasons why juveniles should not be able to obtain life sentences without parole. It's been proven that the brain of a juvenile at an early age, it's impossible for adults to have the same mental ability as adults. In adolescence, the zone of proximal development is still relevant, which is the gap between actual development and potential development. Children are still figuring out a sense of impulse control and don't fully understand the consequences to their actions. Along with this, they struggle with societal pressures in order to fit in with a certain crowd. They simply don't know who they are yet. The social learning theory states that children learn behaviors by observing the behaviors of others and then reproduce those behaviors. Most juvenile offenders, based off a survey by Sentencing Project, revealed 80% of juvenile offenders grew up with violence in their homes. Not only is the psychological aspect a vast reason for why they shouldn't be sentenced to life without parole, stems from the fact that individuals are still being wrongfully convicted today, as well as the fact that incarcerating a juvenile for life is very costly. Now that you've heard the other side, here's our rebuttal. For the social learning theory, the crowd they surround themselves with will still influence them to continue a life of crime that could lead to more heinous crimes. Also, courts focus on an age instead of crime. The juvenile courts have a strong tendency to focus on the age of the offender rather than the actual nature and reason for the crime that they committed. A 10-year-old boy who shows no remorse for his crime will still be given a extremely lax sentence because of his age. To say that they don't understand what a heinous crime is doesn't reflect to the behavior that is shown in the heinous crimes like murder that they commit. Juvenile crime is on the rise. In the past few years, we have had a record numbers of crimes being committed by juvenile offenders. This is a scary fact because it shows how the boundaries are being more and more blurred for these young people. Many of them are aware of just how flawed the juvenile system is and use it to their advantage. If we don't have things like a life sentence for juveniles, what is there for a deterrent for these young up-and-coming criminals that are juveniles? Then lastly, there's the right to a trial by jury. The juvenile courts do not have a jury. Instead, the judge makes all the decisions, often with the help of a team of mediators for the children. Being tried as an adult for heinous crimes allows for their peers to decide if they are fit for a life sentence for the crimes that they have committed. To conclude our presentation on juvenile life sentence without parole isn't cruel and unusual punishment, we say that giving a juvenile's life sentence does not fall under a legal definition of cruel or unusual. Juvenile life sentences are currently only allowed in 29 states, and there is no mandatory minimum when sentencing. Life sentences are only for those who are not able to be rehabilitated through their time to juvenile detention centers. And lastly, juvenile life sentences should be preserved for the most heinous of crimes committed by a juvenile because to commit a crime like that shows some acknowledgement of the actions they're committing and the maturity level to understand the consequences of their actions as well. Now we'll take a second to acknowledge our references for our presentation.